Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about Section 8 of the Evidence Act. And Section 8 of the Evidence Act refers to things done or said by conspirators in reference to a common intention. In my last class, I discussed about Section 7, which refers to facts necessary to explain or introduce relevant facts. Now, in Section 8, we are going to divide it into three different parts, and this is the part 1 of the lecture. The reason we are dividing it as so is because Section 8 is quite lengthy and we need to understand the nitty-gritty of every part. Do you understand that? So this particular lecture, I'll be perusing through the three subsections we would find in Section 8. So let's go straight to the first. The first subsection, that's Section 8, subsection 1. It tells us that where there is reasonable ground to believe that two or more persons have conspired to commit an offense or actionable wrong. Now, anything said, done, or written by any one of such persons in execution or furtherance of their common intention after the time when such intention was first entertained by any one of them is a relevant fact as against each of the persons believed to be so conspiring, as well as for the purpose of proving the existence of it. That is the existence of a conspiracy. Now, this Section 8 is for conspirators. If you go back to your criminal law, you would know that there is something known as conspiracy under criminal law, which means A and B and C, three of them have conspired to do a particular thing, which is an offense. And in this case, it doesn't only go to a criminal case, it also goes to civil cases. That is why you will see in the second line, it says, where there is a reasonable ground to believe that two or more persons have conspired to either commit an offense or actionable wrong. So it's both civil and criminal. But let us paint it a little bit in the criminal sense using my example. So we have A, B, and C who have conspired to kill D. Three people have conspired to kill D. And if you look at the rules of criminal law, it tells us that for there to be a conspiracy, there must be an agreement. There must be an element of agreement. They must have agreed to for a conspiracy to suffice. And that's the case of R versus Majekodumi. So in this case, if we want to prove a case of conspiracy, what one party has done, can we prove it as against the others? So A, B, and C set out to kill D. The act that A has done in furtherance of that common intention to kill D, would it be used as against B and C in a criminal proceeding? That is the question that Section 8 is to answer. Do you understand? So let us look at the elements of Section 8 sub 1. Number 1, there is reasonable ground to believe. Now, I am going to explain this in further details subsequently. But for now, just hold it on one hand. There is reasonable ground to believe. Number 2, more than one person. You cannot activate Section 8 except you have more than one person. Number 3, anything said, done, or written. It's not just conduct. It is conduct, statements, and anything written. Do you understand? Number 4, the thing said, done, or written must be in furtherance or in execution of the common intention. Do you see that? So if A is doing something that is not in furtherance of common intention, or is doing something entirely different, then you would say that that would not be used as against B and C. I'm still going to explain that later, but I want you to at least get a grasp of what the elements of these sections are. And number 5, the thing said, done or written must also have been done after the intention was first entertained by any of them. Do you see that? Now let us go to section 8 subsection 2. It says, notwithstanding subsection 1 of this section, statements made by individual conspirators as a measure taken in the execution or furtherance of such common intention are not deemed to be relevant as against any conspirator, except those by whom or in whose presence such statement was made. Now, if we look at the provision of section 8 sub 1, it says that anything said or done in furtherance of the common intention. But now if we look at section 8 sub 2, it now carries statement. I said statements made as to the measures taken will not be used against B and C. So if A makes certain statements as to what he's about to do, although in furtherance of the common intention, here we are referring to his statements. His statement will not be used as against B and C, except he made those statements in front of them. Do you understand? So let us look at the elements of this section. Number 1, statements made by individual conspirators. That's why I put in brackets statements, not acts. Number 2, as to measures taken in execution or furtherance of the common intention are not relevant against conspirators. And number 3, except those statements were made in their presence. Can you see that? So you see, you might not be able to understand this very well, but when you get to the explanation section, which is going to be in my next class, I think it will give you a proper knowledge as to what we are talking about. But let us get to section 8 subsection 3. Evidence of act or statement deemed to be relevant under this section may not be given until the court is first satisfied that apart from them there are prima facie grounds for believing the existence of the conspiracy to which they relate. Now, this is why I told you, when you go to first subsection, it says there is reasonable ground to believe. And at that time, I told you, don't worry. At the later part, you will understand. Now, let us go to the element of section 8, subsection 3. Number 1, there are evidence deemed under subsection 1 and 2. Number 2, they will not be accepted into evidence prima facie on the face of it. And number 3, except the court is satisfied that apart from this evidence that you're about to admit using section 8 subsection 1 and 2, there are prima facie grounds for believing the existence of conspiracy to which they relate. So, excluding this testimony or this evidence that you are about to tender by virtue of section 8 sub 1 and 2, are there other things that we can see in the fact of the case that can tell us that, okay, there is a reasonable ground to believe? For example, if they were caught in the act of robbery in the bank, so they went to rob a bank and one of the bankers was smart enough to alert the police and the police came and surrounded the bank, that alone is a reasonable ground to believe that there is conspiracy, which means that you can activate section 8 the moment that has been admitted into the court. That is the fact that they were arrested at the crime scene all together. Do you understand that? But if they were arrested individually at different places, you arrested one at Mushi, you arrested another at Ajegunle, you even went as far as Enugu to arrest another, and now you want to use what the person at Ajegunle said, you want to use it as against what the person in Enugu is saying. The question is there anything outside the fact that can prima facie prove that yes, this person in Enugu and this person in Ajegunle were both conspirators? If there is nothing outside the fact, you cannot trigger section 8 to your own advantage. For you to be able to trigger section 8, you have to have something else in the facts. Do you understand? And so with this, we move on to our next class, where I'm going to explain in total, using certain cases like OSHO and the state and UBIERHO versus the state, to give you a clearer perspective as to how section 8 works. So with that, I will see you in my next class.